Welcome to Bad Law, Worst Facts. Today I have on Stephanie Rhima, who just off air just told me she's tried 45 cases, which is unheard of. I thought it was going to be like 15 or 20, but 45 is a ridiculous amount. Stephanie used to work for Allstate back in the day, or a few firms after that, and then started off on her own defense, and is now getting no neg verdicts against some of my friends. It's really annoying, but it's good. Good. I asked
I'm
you to come
always
on the
gonna get
pod.
you that verdict against your friends, though.
That's fair. That's fair. That's fair. I'm waiting for one against you against me, just for some fun. But we'll see. But what I wanted to talk to you about the podcast today is a few things. Originally, I wanted to dissect a jury trial that you did recently, and I won't get into like the specifics of that trial. One of the things I noticed is that you tend to embrace facts really well, like to the point where you'll kind of almost embrace liability and say, look, like, yeah, these things happen. But that doesn't mean that someone should pay 250,000, 300,000, $1 million when this happens. Do you think that deflates the plaintiff attorney's case a lot?
Yeah, I think that if you're gonna go into a trial where liability is clear, then the best case scenario is going in and taking accountability, because otherwise it's gonna make the jury want to punish you. And I think that that was one of the things that went well for that trial, is that attorney specifically just kept trying to say that we weren't taking responsibility, but it was clear to the jury that we were. And so it just made the attorney lose credibility with the jury.
So, coming from kind of like my standpoint, I do think when a lot of plaintiff attorneys go into depositions, they want the defendant to say, I'm at fault. And I think they want that because from an insurance standpoint, maybe it helps trigger Stowers a little bit more, right? But I actually, for a trial standpoint, I actually like when the defendant is almost fighting and saying, especially rear end collisions, it wasn't my fault. It's not that big of a deal, kind of harping on that. In fact, I have a case going against an insurance company in June that's exactly what's happening. I'm excited because I think juries do not like people who do not take accountability, right?
Yeah.
And so I do think you're right. I think that from a defense standpoint, and it's rarely done, right? It's rarely done. Every single time I've seen an insurance standpoint, it's always an insurance defense standpoint. It's always fight liability, even on the most severe rear ender that's being classic, fight it in hopes that there's a no neg verdict, right? And I think that's the wrong way to look at things.
Yeah,
I
I
think
agree.
I think it does. It kind of blows me out because you want the jury to get riled up about something. As much as we like, they're not going to get specifically riled up about medical treatment. They'll feel compassionate, maybe, but not riled up. So I agree with that. What about the medical side? Tell me a little bit about that. How do you as a defense attorney look at a case and say, this is garbage, this is real? I mean, the number one thing I think is gaps in treatment. Oh, what else?
I think gaps in treatment, later to go to the ER, urgent care. Also, just, having a good deposition where the plaintiff doesn't seem to know any of the treatment. Because, as you know, we get to trial and all of a sudden they know all about the treatment, they know how much the damages are. So, as a defense attorney, if you go into the depot and make sure you ask and they don't even know where the location is and they've been there 15 times, I mean, the jury's going to get to trial and be like, clearly this wasn't as bad as it seems because they can't even remember the treatment. And then you can show that it's really the attorney that's driving everything, you know? But I feel
Mm.
like also for medicals, like it just depends. Like, what's the damage to the property? Was there police involved? Those facts matter. Did they drive the vehicle back to their house after? Were they going to work? I mean, if they're going to work and they have a manual labor job and they just continue working like nothing happened. But also, like some of these providers, they have charge master listings online, or like they don't have the required licensing. And so I mean, I like to look at the medicals not just about how much the money is and like looking specifically at what they were doing and did they have the right licensing. Because if there's no licensing for that I'm going to milk that avenue because it puts pressure on them, because they're not going to bring a provider live that's going to testify if they don't even have the required licensing for like ER care.
Walk me through that. What do you mean by require licensing for that?
Yeah, so I've been doing this a lot more recently, and I feel like a lot of attorneys don't realize, but like if you're going to bill for like an ambulatory surgical center, urgent care, a hospital, or a freestanding ER, all of those facilities are required to be licensed with the state of Texas. The Department of Health requires it because it's like a higher level of care, and it's called a facility fee. And so if you're going to build a facility fee, you have to actually have the required licensing. And so if I notice a facility continues to send a facility fee for like injections and they don't have that licensing, I'll make sure to send admissions, like admit that this facility is an x-ray facility, because most of the time they are x-ray facilities. And that way you can show the jury, like, if it gets there, that they don't even have the actual license to build this. They're just trying to make more money. And the judges are letting it in because of the Hospital Transparency Act. I don't know if you noticed that trial I had mentioned something questionable about the hospital. And even though I didn't get into it as much as I liked it, the jury heard it.
Yeah, did you pull the jury afterwards on that one?
Yeah, we did.
Did they look at it as like, for lack of a better term, like a kind of attorney driven?
Well, yeah, but also that plaintiff had like prior accidents and subsequent accidents. He couldn't remember. It was very clear that this guy was like milking the system, and the jury saw that. And the attorney didn't clean up all that.
Sure. So it's kind of funny you say that. So I make it a point. I had a plaintiff deposition this morning, so and you were super busy. So that's why we did it in the afternoon. But I make it a point that the client has to look. I get it from a client's perspective. You went to these places, whether I sent you there or something like that, whatever it is. You went to these places. You probably don't remember the name because it's been like a year, 2 years, whatever it may be. But you've got to, tell the client this is where you went, prep them on it, make them understand this, so that when they go in there, and usually when you tell a client, "Hey, do you ever go into X?" They're like, "Oh yeah, that's the name of the place," right? That's super helpful. Saying, "I don't remember this, I don't remember that, I don't remember this. I kind of vaguely remember what the chiropractor did." And you remember, I've been to a chiropractor, right? For treatment. So I know, like, I remember them putting this thing that shocks me a little bit because it feels weird. I remember them doing this roller thing because it feels different. I remember them cracking my neck because you're terrified when they do it for the first few times, right? So you remember these things. And so it's not very hard to prep them on that. But do it before the deposition. And that kind of asks me to the next thing. What do you think about defendant and plaintiff, both of them, the way they come off? Does that give you a certain sense of, I should go to trial in this case versus I should settle this case?
Oh, yeah. I think witness impression, like, that's why I always want to get the plaintiff depo, because even if they submit these excessive bills and it's maybe 30, 60, I'm just like, I want to meet the plaintiff, because that will make it or break it for me. Because if it seems like they're very sympathetic, like I had a case the other day where the accident wasn't severe at all, but the plaintiff was very sympathetic and she was crying throughout. She had lost her brother, someone recently that was important to her. And I could just tell, like, she would come off as a favorable witness. And so I did advise my client to settle, and we did. So I think that plaintiff depots are important, and the defense depots, and prepping the clients. But I know a lot of plaintiff attorneys have been trying to slip these little summaries with the plaintiff depots since it's virtual, but that's not going to fly with me.
Wouldn't you be okay with something like that if they made it an exhibit?
See, that attorney didn't try to say it wasn't an exhibit. And I was like, no, it is. And he, like, after the call, he was like, you're a good lawyer. I'm like, why? Because all these other lawyers are letting it fly. Like, he literally came up with his BS argument of why it was allowed and that it was attorney-client privilege, but his client was using the document. And I was like, get rid of that document now. And so he finally, like, his client moved it away. That's not attorney-client privilege.
Years ago, I don't do it anymore. Years ago, on larger cases, the client goes so many different places, right? And so I would mark it. I would say, hey, this is exhibit number 1 to the deposition. This is the client's summary of his medical records. Here's a copy. This is back when we're in person. And I would just let the client look through it and have it. I probably would look at it before, obviously, but just in case he needed the crutch to do so. And so, I wasn't playing any games, right? And defense attorneys used to make a big deal about it, but whatever.
Yeah, I mean, I'm gonna make a big deal out of it because I want to know if this guy remembers it. And sometimes they don't even like. I don't lead questions. I'm not like, did you go to this hospital on this day? Like, that's not a very good defense step of the defense attorneys coming in and saying, and then you went to this pain management, right? And then here, it's like, well, are they testifying or are you? You know?
I like doing this because my client doesn't have to remember. I get it. I get, because I wouldn't, if I was on your side, I wouldn't do that either. The flip side of that is, what are some techniques from the plaintiff's side? Because, like, I do my thing, right? But you see so many plaintiff attorneys. I mean, 10 times how many different things I see. What are some things on the plaintiff side that you think are beneficial for plaintiffs to know when they go up against a defense counsel? If that makes sense. And I'll tell you some from the plaintiff side about defense counsel.
Yeah. Like things that they do that they shouldn't do, or like
Flip side, things that you like that you see rarely.
I don't know. I really like Tottie's like deny, delay,
Delay,
defend. I love that.
delay, deny,
My dad
defend.
is always like, my dad will randomly text me and be like, delay, deny, defend. Like it's not an inner joke, but that was good. But I don't know. I think that as a plaintiff attorney, I think the best move is to like come off reasonable because I think that that's the one mistake that happened in that last trial is he like requested too much money and he under delivered. Like if he came across reasonable at the beginning, then I don't think the jury would have been so turned off. But since he wanted millions of dollars, the jury was expecting $1 million facts and they were literally not, you know?
So I sat second chair on a trial. It was a parking lot wreck, and the plaintiff's counsel for it, the plaintiff's counsel for it, not me, wanted asked for $2 million. I was like, is this what we're doing here? This is what we're doing? And obviously the jury, I think they kind of would have went with us if we didn't ask for so much. There's like a whole, on my podcast, we just had Sean Claggett on, it's called, and he did jury vault. There's like a whole thing like, there's a certain point in time where the amount you ask for just completely destroys how much you can, get away with. But,
Yeah.
being reasonable is super important, especially in car wreck cases. So for the defense, the number one thing you actually do it is the accountability defense. Like, if you're like, look, I'm so sorry, you even turn to the plaintiff, I'm so sorry my client did that. My client's super sorry. Oh, we can't ask for this much money. That comes off so reasonable, destroys the case for a plaintiff attorney. And actually, that was in Randy Soros' case where he got that $357 million verdict. That's exactly what Rusty Hardin tried to do at first, but he's kind of messing it up because then he ended up getting like all these people to say it wasn't our fault at the same time. It was really weird. But if you stick to that, I think that's really good.
And I think like the damages defense, obviously, like you got to go in and decide what your plan is. Because I mean, even if you're going to go in and say, yeah, like it was an accident and he did rear end. You also have to have the combination of this isn't reasonable treatment. He wasn't injured. I think that's the best case when you can argue both sides. Because I mean, a no negligence can occur on rear end. I mean, my case was a rear end texting accident, and I've had many no negligence on rear ends. I
Oh
mean,
yeah,
like, so I think it just depends on how you present it to the jury. So, I mean, I've seen cases go sour too, because you don't personalize your client, and, you know, I think it just depends on the defense witness as well. I mean, I don't know about stipulating liability. I mean, I've never really been into doing that.
I don't think it's a good call from the defense standpoint to stipulate liability unless the
Yeah.
facts are egregious.
Yeah, if you don't want some specific evidence to come in, like alleged drinking and driving, I could see the point of doing a, because then you don't have to deal with, whether he was at fault and you can, try to mitigate the egregious facts into the case. But
But if
usually
not,
those cases are going to get settled because if you have a good defense attorney, they're going to tell their client to accept the policy limits demand.
fair.
Yeah.
With and it's kind of weird, like with jury charges, juries, even though they are instructed by the judge and the jury charge is pretty straightforward, they always have questions. They're always confused. And so you kind of want to give them the leeway, in my opinion, for a defense counsel. You always kind of want to give them the leeway to put that no neg on there so they don't have to answer the rest of the questions,
Yeah.
right? So I get that. Obviously, barring any egregious issues. The flip side is, have you tried a case yet where a plaintiff attorney has non-suited past meds?
So I think I have, but I don't remember it very well. And I don't think it didn't go well. They didn't even, I think I mentioned they don't even have medicals. I don't remember. But I don't think it was one of those cases where they really went the reptile theory and like tried, like, But I also have already like studied the reverse reptile theory and I would know how to counter that. I mean,
Okay. Okay.
I just
Hold
feel
on.
like I feel like if you just reverse it in the sense of like I feel like a lot of people know that insurance rates are going up, everything's expensive. And like if it is a case where like there was no it depends. Like again, like did the airbags deploy? Did they go to the ambulance? Did they report an injury at the scene? Like what other facts are there? Because I mean, also keep in mind we have Gregory versus Shohan now. So it's like you have to actually have damages when you go to trial. You can't just say, you can't do economic ratios anymore. You can't do like compare it to your damages. Like it's very specific. And I only learned all this because of studying for the board exam. And I was like, oh wow, like I didn't realize that they can't just award a bunch of money if you don't have the actual damages and evidence. So I don't know how the reptile theory would work that way if you don't have it must be a serious injury case. And if so, like I said, I'm not going to try that case because my client's going to settle. So yeah, I have tried a lot of cases, but a lot of them and all of them I won because of the fact that I make sure my clients aren't going to trial on a case that's going to be risk. And if it's a case where we offered a reasonable settlement amount, then it's easy for me to go to trial and tell the jury a reasonable settlement amount because I'm going to give them reasons of what's reasonable.
Right. It's funny that you mentioned that. I think Gregory's given us no real guidance whatsoever for the plaintiff's bar on how to deal with mental anguish and with these non-economic damages. It's not helpful at all. It's only told us what we cannot do. And so it's a little
Exactly.
frustrating, but
I feel like for example, my last trial, like what arguments did you make to even justify that amount that you're asking for? Like there was not any. And I feel like as an attorney, like there's got to be some disruption in your life, like some serious injuries. I mean, as a plaintiff attorney, I would make sure that I went through my client's life with them to find out any type of disruption that I could try to like just heighten and bring it to the jury's attention, you know?
now we're talking. Okay. So that's super important, right? I mean, if you're going to make that argument, then you've got to kind of almost do like a day in the life of the client so that they see, look, these are the issues that I'm having. This is what's occurring.
Yeah.
Quite a lot though.
I mean, yeah, but if you want to make a lot of money, then you need to go to the trial and actually bring the evidence, have the witnesses. Where's the family members saying that your back was hurting every day? You couldn't walk the dog anymore. You couldn't even play with your kids anymore. Like, I want to see that evidence, and I want to actually see it.
Yeah, I'm cautious about family members. I think it's good, but you need collaborate it with like someone else that is not related to the family, like a coworker or something like that. And potentially more distant to coworker, the better, right?
Yeah.
It's way more helpful. But yeah, I agree with you. I mean, tell me something else. As the plaintiff side, have you seen it where the attorney driven stuff doesn't actually affect the trial? Besides, well, they just didn't get the liability.
Well, I mean, I feel like, like ensuring that you have some jury members that have done chiropractic treatment, like you
Right.
want to get people like that are like, it's okay if they went to chiro and they got their treatment and that they went and got their MRI. I mean, honestly, I feel like what the most important part of the jury trial, which we all know, is jury selection. And like, it's going to make or break the case. I mean, that last case, there was a guy that had an amputee and like we didn't notice it because we were all sitting, yeah, we were sitting like they were sitting in the jury in the audience and like you couldn't see
Yeah.
him, and once he got picked he had been like in the military, and it was just like this guy is not going to be okay with this plaintiff like alleging soft tissue injuries. So That I do think the jury's everything in these cases, asking the right questions, but also not turning off the jury during voir dire, which I see plaintiff attorneys do every time. And that's where I think that the plaintiff attorneys start off on a bad foot, is because they start off first. I'm going to be asking for $1 million. Who's here okay with it? And I don't think that's a good move for the plaintiff attorney, because what if your client doesn't present well? Why would you set yourself up for this? If you could just not do that and just do general questions, like how do you feel about awarding pain and suffering? Like, you don't have to say, I'm going to ask for all this money.
Yeah, you think that it causes them to have to ask for it, even if the trial's not going as well as they'd like? Or what are you worried about that?
Yeah.
You just feel like it kind of shocks
Yeah.
their
Because
conscience at the beginning?
I use that every time. I'm like, you heard him. He said he's going to ask for $1 million. Like, I use things that they say in voir dire against them during opening and throughout the whole case. So if you're going to go in there and, ask for a lot and not deliver evidence worthy of it.
Have you heard of inclusive voir dire?
No.
So inclusive voir dire. So exclusive voir dire is what the traditional is, right? You're trying to get juries off for cause. You kind of try to fish around. You're trying to find the perfect set within this bundle, right? Hopefully, they're closer to the top 24 at the beginning of this so that you can get there, right? Inclusive voir dire is to say, that's not going to happen, right? I mean, it could happen. There could be some ways that I can get some people off, but I want them all talking in agreement with me. It's kind of like the salesman, where it's like, as a salesman, you want the person on the other side to say yes, 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 yes. So they're like, oh my God, I love this guy. I love this guy. It's the same thought process, but inclusive for dire. So like, a terrible example, because I can't think of anything else, is, you know, uh, we've all been in a car wreck. If you're stopping at a light and you're rear-ended, it's not your fault, right? Who agrees with that? Oh yeah, I agree with it. I agree with it. Because if the other guy says that they're not at fault, that would be ridiculous, wouldn't it? Oh yeah, that would be ridiculous. And we all agree that would just be absurd, wouldn't it? Yes, it would, right? And so you've gotten everybody to say yes. They've also gotten everybody to say, if this is what the other guys say, we're going to have a very, very short trial when it comes to liability and a very long conversation about why we're here, right? And so that's kind of the inclusive method, in hopes that whatever bias they may have coming into it is going to be dispelled by them being kind of in a sales method, right? Like you're like, all right, let's go, and do it. It's kind of like when you go to like a gym for the first time.
Yeah.
And like, you're like, oh, this gym's awesome. This thing's great. And that's when they hit you with, oh, and this is how much it costs. And you're like, whatever it takes. And you're there. And you're stuck. Same thought process. Yeah, I like it. No, I like it a lot. And then, so I've been kind of, hopefully the one in June, the trial in June, I have like this whole implementation of it. So we'll see.
Yeah, I have a new client that's a big trucking company client, and I've been thinking, because they've been giving me some liability denials, and I'm like thinking of a jury with an 18-wheeler and thinking like how to make arguments to them about how just because it's an 18-wheeler doesn't mean that they're automatically at fault. They have to pay all these big damages. So when I mentioned the reptile, like reverse reptile, it could be almost like, making the jury see like these 18-wheelers actually help our society and like economy. They carry petroleum, like things that are dangerous, but like they have to do it. And if they don't do it, who's going to? And, the company's following all the rules, the regulations, and an accident happened and it wasn't even their fault. And they still have to be here today to fight it because of the fact that they're a big company. So my main question to the jury would be like, can you find no negligence and no fault, even if it's a huge trucking company that might have deep pockets? But that's not the point. The point is that he wasn't at fault. And I need a firm commitment from everybody in this, like, that's going to be selected, that you can find no negligence, even with a big trucking company. And I think that would work, because that case, like, we have the police report and we have a witness, and, obviously the plaintiff attorneys don't care if they're at fault or not, because it's a big trucking company and they know they have deep pockets, and they're probably thinking, they don't want to fight it. They're just going to pay us just something to go away. But my client isn't going to pay it. And I think that we need to set like the record straight that, liability, if it is in dispute, then, we will take it to trial, even if it is a trucking company that has deep pockets.
So I think on any case, whether it is a trucking company or car wreck case, your mentality on the plaintiff side should be prove it beyond a reasonable doubt. I know that's not the standard. It is not the standard, but you have to do that because if you continue to do it and you gear your practice that way, right, you're going to have good results. And if you don't, someone like you is going to come around and be like, look, this is disputed. It is 100% disputed. Here is what I have done on my side to show that we're not at fault for this. And the jury's going to go your way, right?
Yeah.
I mean, so far they've done it so many times.
Yeah.
So you have a proven track record for it. I like that idea. I do think you could add a little bit more diversity to it, right? Like, look, we all have jobs, especially you have some small business owners on there. Do you think that just because you own a small business, someone should come sue you and take all your money? Kind of like, and they say no, be like, because that would be messed up, wouldn't it? Right? And kind of push through that way. But I like that, you're not wrong. I do think a lot of attorneys take disputed 18-wheeler cases. When I take a disputed 18-wheeler case, it's because I've noticed some issues with the case that I think the 18-wheeler has to answer for, right? But there are some that will take it just to take it because they think an 18-wheeler company is just going to pay. What they don't realize is that some of them have like SIRs, which are a huge pain in the butt for the 18-wheeler companies, and sometimes they just don't want to pay it. SIRs for our viewers is basically the 18-wheeler company has to put up a certain amount before the insurance kicks in. And sometimes they don't have that much money, right, to do it, or they don't want to. But the insurance company will provide a defense for them. So you won't know until you file, and then you get the policy. Anyways, so I don't disagree with you. I do think it should be fought. I think in hopes that it winnows around the good plaintiff attorneys that will actually do the work to show you, hey, look, I think you guys have problems enough for you guys to say, okay, there should be a resolution to this case. Maybe the plaintiff attorney doesn't like it, but it's better than trial for both of us, right?
But sadly, that's not the plaintiff attorneys that I'm coming across. I mean, it doesn't matter. They're just, for example, I have a case where the plaintiff was literally getting arrested for drinking while driving and has a past history of driving like DUIs, DWIs, and a plaintiff attorney took the case, sued my clients who were not at fault for the accident, have a police report, have the public video showing he's taking a field sobriety test and failing, and the plaintiff attorney still took the case. I think that was probably one of the most egregious plaintiff cases I've seen. Like, why would you take a case where your client's drinking and driving and then sue the injured parties? So anyways, a plaintiff attorney friend had me come in and represent his clients because his clients that were the plaintiffs were sued. And so I came in to help with that one. But I mean, you'd think that an attorney would evaluate and look at the case and see, but some of these attorneys aren't. I mean, but also as a defense attorney, you have to show the plaintiff attorney. So I have a case where it's liabilities in dispute, but instead of going common sense, I am going to get a accident recon on it because it was severe damages. And if that accident recon comes back and he rules with plaintiff, then it helps me get the case resolved. But I think one mistake, a lot of attorneys take a file, they have high volume, they don't look at it. And if it's a liability denial as a defense attorney, you still need to look at the file and think, is there potential that a jury's not going to be able to determine fault? Like, should we get a police accident recon if it's very serious injuries? Because we don't want the jury feeling bad for the plaintiffs and putting it on my guy just because,
Have you tried a case? I agree with everything you said, by the way. Have you ever tried a case with a low PD?
Yeah.
Okay. Have you tried a case with low PD when the pictures don't get in versus they do get in?
Yeah.
You think it makes a difference?
I've tried a lot of cases in Harris County where PD, this was before, COVID, before COVID time. That's when I tried a lot of cases at Allstate, and PD didn't come in half the time. And, it didn't make a difference because it was, more of, the medicals and the jury just assessing witness credibility on the stand. And then, oftentimes they went straight to the chiropractor. No ER. And if they did go to the ER, the best defense is if liabilities, we did accept responsibility. It was just an accident.
Right.
If you really buy this, then just give them the ER treatment. If you feel like your case is going sour at trial as a defense attorney, you should definitely be just give them the ER. But other than that, they haven't proven that this was caused by this accident, And you don't go into trial with an outline or what you're going to do. If you're a trial attorney and you've been in trial, you know that you try the case as you're in there. Like things
Right.
come up and you just have to like go with it and make judgment calls. Like, you know, and also not telling if there is a clear liability. And obviously for my last trial, I said give nothing, because by the time we got to the jury's like deliberations, the jury was also just like, this is BS. But if you feel like, okay, the jury might give something, it's actually better to suggest numbers, because I know that sometimes the juries don't know what to do. And if you just leave it for them to decide, it's like they already heard plaintiff's number and they don't know what number. So if you give them a range.
Floor kind of situation. That's how I
Yeah.
look at it. That's giving them a floor, and I'm giving them, hopefully the right number. But
Yeah, but then as a defense attorney, I'm going to be like, he's asking for that much because he knows the higher he says to you, you're going to come in at some reasonable number. But this is
right,
actually the reasonable number, and I'm not playing the game of going too high so you come in middle. You know?
anchoring. Yeah, that's right. That's fair. What do you think? Do you come at it like I'm the voice of reason and this guy's a wackadoo? That's how I've seen. I won't say the last trial, but
Well, the last
I
time
didn't
I
watch.
did do that.
But you've done that before. I've seen you do that.
Well, this last trial, like, it was just so appropriate because, first off, the attorney got up there and started spitting out the burden of proof incorrectly. So, like, when I got stood up and I'm like, Your Honor, he's incorrect on the burden, and the judge is like, she's right. It's just like the jury, like, immediately, like, thinks, okay, this girl might know more than him, you know? I don't think I do that often, though. It just depends if the attorney's saying stuff that's incorrect, you know? But you don't want to come off like the cocky lawyer that knows everything. And you got to be reasonable and you have to make the jury like you. I feel like jurors like my passion and they like see this female, it looks younger. And like all of the juries after my trials, have always told me are so passionate. And like, I think that passion and like being I don't, the jury just seems to like lawyers that aren't dry. And I've just seen a lot of the lawyers come in and they're like all over the place. They don't even seem like they know the facts of their own case, and that does not sit well for jurors. I mean, jurors have told me many times I need to be a little bit more organized, all papers everywhere. So I don't know. I think organization is important.
Organization is important, as well as how to deal with. You got to. There's another book about this, but jurors want to be led, right? It's kind of like a teacher. So if you are a teacher, the students are going to follow. But if they look like they think their teacher's inadequate, that's going to be a problem, right? And so at all
I,
times, you kind of want to. Commanding a courtroom, I think, is such like a shitty way to say this, right? But more like you are in command of everything and every action that you are doing, and letting the jury know, I just follow my lead. That's one thing. I have to admit, yeah, you are very good at. Uh,
Thanks. Yeah, I think that one of the like real fast though on this is like I
yeah,
think that's one of the biggest things that an attorney can like if you lose the juror's trust because you go tell them something and then the defense attorney points it out and is like shows that he's lying, the jurors like lose you. And once they don't trust the lawyer, they don't even it's like they don't it's all I know they say popularity contest with lawyers, but I mean, it is important. If the jurors think that the attorney's a liar, they're not going to side with their
yeah.
client.
So like, what else are you lying about that you told
Yeah.
me, right? That goes back to what I was going to say earlier about the attorney-driven thing, right? One of the things I'm working on in June is to deal with that. And what I'm doing is in Modiah, we're going to talk about it, right? We're going to bring it up during the opening. I'm going to be like, yeah, this is exactly what happened, right? It's not my case. It's a previous attorney's case I'm litigating, but I'm like, yeah, this happens every single day. You get in a car wreck, call an attorney. They send you to a place that treats people who have been involved and who know how to treat people in car collisions. This is not like we're driving anything. It's not what we're doing anything. These people how to treat these people. Would you go to someone who doesn't or does? Kind of go through that mentality, right? But just embrace it, accept it, let the jury know. And I'm hoping that kind of cuts the wind out of the defense for it. We'll see.
Yeah, but you have to be careful because what if attorney client or attorney driven isn't even coming into evidence? You don't want to go. I mean, obviously, if the judge says attorney referrals allowed.
Yeah. I mean, I have a
I
motion to
mean,
eliminate, but I strongly believe it's going to come in. Because
you
to be
do.
honest with you, that's their only defense. Everything else, I mean, we've got everything I've got 6 or 7 witnesses coming down, right?
That's their
So
defense is attorney driven. That's a terrible defense. Like, who cares? Like, do you have like counter affidavits to make the providers come live and then you cross examine to show the bills are unreasonable and like his whole practice is attorney driven and that he doesn't actually get paid what he's expected to get paid? Because
they do
I
have
don't
counter
think
affidavits. Oh, we could do this live. Why not? They have counter affidavits. They're coders. One of them is a defense expert who testified that actually it's two of them. One is a Cairo. I took his deposition. He said that my client should not have had 6 weeks of treatment, that it's all BS, and he would not have recommended MRI, and that it was overbilled. So there's a few things I did. One of them is I used fairhealth.org. Fairhealth.org showed that it was above what my clients were billed for, what the reasonable about, and then my clients under, right? That's good. Two, the day that he said he would release him from treatment, the client had 10 out of 10 pain. And I said, what would you do if that was your patient? He said, I would send him to an ortho. I said, what would an ortho do? I don't know. Guess what an ortho would do? Probably send him to get an MRI. So, and then there's also some background in that guy's stuff. So, I'm not super worried about that. I am worried about just the sole fact that the client waited about a week and then showed up to the ER because he started having really bad knee pain and started like swelling up. And he's like, all right, I need to go somewhere. That's the biggest issue in the case.
that really that just the week gap. Is
They
it
don't want
like
to pay me.
weekends? Was there a weekend or?
It happened on like, I think a Thursday, and he went that Tuesday.
I don't think that's a gap at all to worry about because I mean he wanted to wait until the weekend to see if the
Yeah.
pain subdued and he went next week when it wasn't. That's I mean I've seen 6 months gap in treatment or 30 days. Like that's literally I wouldn't even describe that as a gap if we're being honest.
I don't think it's a gap at all. They're making a big deal about it. Obviously, they make a big deal about that. They make a big deal
And
about
I would
a
highlight that during your trial. Like they're making a huge deal about this couple days, acting like it's a huge gap in treatment. Like this isn't a guy that waited 6 months or even waited 30 days. He literally just waited the weekend to see if it would subdue. And because he wanted to, not go and rush to the ER if it wasn't necessary. And he waited and it felt necessary. So he went on the Tuesday after the weekend.
yeah. How are
And then
you?
the attorney driven, I don't think the attorney pushing treatment. Like, I think that if an attorney was really hitting on the like attorney referring, all I really ask is like, did a medical doctor refer you to this provider?
Right.
I don't make it a huge scene because some of the juror members have been to Cairo and you don't want to offend people.
Yeah, I agree with that. And then a lot of times in Fort Dyer, I've done this a few times, I will actually ask who here's been part of a personal injury action. Tell me about that. And they're like, well, the attorney actually sent me here and here. Were you hurt? Yes, I was. Oh, and so you kind of clear that up early on. Here's the problem with that, all of that though. All of that is embracing. And I do not think on this side, at least, we embrace it enough. It's okay. It is totally fine. The health insurance industry is essentially broken. To have any sort of guidance in this industry is fantastic, right? And so that's always been my philosophy. And so that I think is helpful. But,
I agree. I don't think they're embracing it as much. I think that what you're saying that your strategy, I think that that's better than like just the typical plaintiff attorney strategy of like not mentioning it. Cause then it's just like the like defense attorney really highlights it. And if you mention it first and clear it up, it makes it not as big of a deal. Like they already heard about it.
yeah, sure. We've got about 3 minutes. Is there anything else you want to talk about?
I've been seeing some attorneys, submitting medical records and bills for multiple claims. And I'm just like, I feel like I don't know what's happened to like ethics and, but if you're going to submit the exact same demand to two different insurance companies for like treatment that's maybe a month apart, you should know that like the insurance company is going to know they're going to start an investigation and you like could potentially become part of that investigation because I mean, you can't get paid for medical bills and then settle that case and then submit the exact same medical bills for another accident. Like which accident caused it? And there's called like the one satisfaction rule. And I've been coming across this more and more. And it's just stunning to me that these attorneys think that they can just do these things because they're lawyers and your bar license can be, investigated. I don't know if you've seen this or heard of it.
No. I mean, honestly, if an attorney's doing that, they're not going to tell me, right? Or they're not going to tell another attorney, honestly. I
It's like just
actually,
file to one case and argue like the independent injury or something. Like I feel like that's a better strategy than submitting the same stuff to two, because then the insurance company's probably going to deny liability and they're going to show the jury like it's a scam. But if you did the independent injury, we don't know which accident caused it. That's the like actual ethical way to do it. But these attorneys lately have been trying to hide that.
So my first year loss of being a lawyer, I had the right idea. This guy got into a wreck, injured, treatment, another really bad wreck. Both of them were bad. And then when asked which wreck caused her injuries, she couldn't answer. I was like, fuck it. We're going to sue both people in one lawsuit. They can figure it out.
That's exactly how you're supposed to do it.
They try to do is they try to bifurcate it and say, well, these are two separate events. And I said, yes, they are 100%, two totally separate events. But here is the medical treatment and no one can figure out where she's injured from. And so what ended up happening is the insurance company looked at it, both of them, and said, look, we'll pay from, this date on. This one said, we'll pay from this date to this date and we'll call it quits. And I was surprised that worked.
I think it's the best route. And then you have both insurance companies in a mediation. You're going to get more money this way. I mean, obviously, maybe the attorney's thinking, oh, I'll get more money if I don't do it together. But then it's like you're looking like you're being sneaky and that's not going to work. Like, I think the insurance company is going to take it more serious if you're, being honest about it, because the SIU department's going to get involved. And if SIU's involved and there's something sketchy, like, they're going to punt the case to me and then I'm going to try the case and I'm going to milk and I'm going to highlight all of the facts about how sketchy, and I have admissions that ask specific questions. I don't know. I just think the attorneys need to take a step back and look at the case and not approach every single case the exact same way, which is what they do usually. For that case, they would have done differently. You know what I mean?
Yeah. I mean, you look at it, you hear this happens. You have to get on it. All this job is being proactive, right? And not reactive. At least on our side, it's always being just proactive. All right, there's this issue. If I don't deal with this issue now, later on, it's going to be a problem.
Exactly. And if you address it with the insurance company and actually like talk to them, and if you say, well, what's the issue here? Why is this? Then it's better, because say you don't agree with liability, like let's figure out how, like maybe the plaintiff depot and then reconvene or whatever it is. Maybe they're missing records. Once it's, the insurance company is willing to work with you and they will put more money on the case if you provide the value drivers to do that. We call them value driver. Was that a value driver? Like maybe the client isn't available and like, he doesn't want to deal with this lawsuit. Like that's obviously grounds to add more money on the case.
Absolutely. Well, look, I appreciate you coming on. Like it's very rare that I kind of get a glimpse into the defense world. It's even more rare that I think from a plaintiff and defense counsel side, we both get to talk about it just like a reasonable objective basis, right? Where we're coming from. And it's super helpful. Spoiler, I mean, I think it's to our benefit that we've known each other since this law school and we both kind of like went tracks. Did we have a case together like early on too? Like
I think so. I think when I was at Allstate.
That's right. That's right. That was like, yeah, a pretty quick case, but we haven't tried a case against each other yet. Gonna happen. But, I generally appreciate you coming on. Are you doing any plaintiff work at all?
So, no, actually, I mean, recently my client, one of my trucking company he's going to have me be a plaintiff for property damage and loss of revenue. So I'm like, okay, that's kind of cool. So I'm going to be plaintiff for the trucking company for the PD claim. But I'm like, whatever. It's not even subrogation. It's just like literally filing the suit and that's about it. I mean, maybe a plaintiff case here or there that's like not against any insurance companies I work for, but I typically don't. I send those over to my plaintiff attorney friends.
Sure. No, makes sense. If someone wants to contact you for you to represent them, how do they get in contact with you?
For my email, Stephanie@rhimalaw.com, or call my cell. It's 214-807-0550. And then I have my website, rhimalaw.com. But that you have to remember, I was at Allstate, and honestly, like any young lawyer that comes to me or any law student asks, like, what would you do? I would tell them to go in-house at State Farm or Allstate, because that's where you're going to get to try cases. And, you learn a lot, and it also helps get cases settled. So, but that was back in Allstate. I mean, I'm not trying cases like that now.
Yeah. Now you just get to kind of pick and choose and be a little more creative in how you do stuff. which is
Yeah, I
always
mean,
nice.
I try to get cases settled for the plaintiff attorneys. I had one attorney say, "Are you going to be acting like how you were at Allstate?" And I was like, "No, no, we can get the case settled."
Yeah, I know. Worse. I'm just kidding. Stephanie, thank you so much for coming on. I appreciate your
Yeah,
time
thanks for
today.
having me.
Absolutely. I hope it helps our viewers, to learn more and more.